4CRB now presents Legal Matters, proudly brought to you by Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. This program provides general legal information only. It's not personal legal advice. Everyone's situation is different, so please seek independent advice for your own circumstances.
And it is a very good morning to Andrew Bell from Bell and Senior Lawyers. This is a talkback program. I remind you now that if you would like to get in early and ask your question of Andrew Bell, make that phone call now. Don't leave it to the end of the program. 0755 208888 is the number. Good morning, Andrew.
Good morning, Colin. Thank you for having me back.
You're very welcome. So we had some carryover questions, and one of them was regarding overseas wills, Andrew.
Indeed it was. So last week I said it was complicated, and I've confirmed that indeed it is complicated. So if you have a will that's from a foreign country, it is possible to register it here in Australia should you die and if you've got property in Australia. However, that may depend on what country you're from. If it's a Commonwealth country, England, New Zealand, Canada, Singapore, our courts have a system to deal with those wills. If it's other countries, then the process is much more complicated, and you're going to have to go through probate to have things registered. You're also going to have to make sure that it complies with both the laws here in Queensland and the laws in the foreign country.
So is there a better solution?
From my perspective, it is possible to have a will that just deals with your property in Queensland. So if you intend on living here for any significant period of time, it's probably best that you get an Australian will to deal with your Australian assets, and you could have a foreign will that's complementary that deals with your foreign assets.
Perfect. All right. Well, that sounds like a better option to me. Decomplicating the world is the easier way to go. 0755 208888 is the number to call if you've got a legal question for Andrew this morning. We've got a 25-minute show. We'd love to hear from you. So grab the phone, grab your question, 0755 208888. Now, we did start a discussion on defamation last week, and we were overrun with calls, which is great. We thought we might conclude that discussion this morning. Now, you've got... actually, no, my apologies. We were going to move into a topical component, jerry cans, and come back to defamation. Jerry cans and fuel storage in Queensland, and we are hearing a lot about people panic buying from time to time or just storing a little bit for a rainy day. What are the rules and regulations?
Absolutely, Colin. I thought this might be relevant, so you do the right thing. The Prime Minister says don't stock up. However, if you do need a jerry can, these rules apply now in these high prices for petrol as well as going forward. So if we start with the canister, if you want to travel on the road with petrol, you need to have an appropriate container to put it in. The rules have changed over time, and now if you have a flammable, which is unleaded petrol, or you have a combustible liquid, which is diesel, they need to be carried in a jerry can with the mark saying UN on it. And that means that it's been tested for leaks, pressure and vapour. If it's not properly marked, then it's illegal to use it for petrol.
Wow. Okay. So these are some of the considerations we hadn't thought of.
Also, where do you store it when you bring it home? So if it's, depending on whether you have a freestanding or attached garage, if you have an attached garage, you can probably only store about 25 litres of unleaded in the garage. If it's freestanding, you can put a little bit more. Inside the house, no more than 5 litres, and you might have issues with your insurance as well. So be very careful if you've got petrol at home where you're actually going to store it.
Yeah, absolutely. There's a lot to consider, especially when it comes to safety, but there are legal components as well. We have our first caller, Andrew. We might go to that, and it is a very good morning to Thomas. Thomas, ask your question of Andrew.
Oh, good morning, gentlemen. I'm calling on behalf of my granddaughter. Unfortunately, her marriage has broken down, and she's got the 3 children and husband. They've been to mediation, to several meetings, and they came to an agreement.
Okay.
Are you there?
Yep.
Yeah, okay, yes. Okay. Now, and they've come to an agreement where, like, for example, the father can have the children every second weekend. He picks them up from school on Friday afternoon, and returns them on Monday morning.
Yep,
so
makes sense.
So all the commitments that my granddaughter was asked to do, she has done. Unfortunately, he hasn't. He was to pay the school fees, doing sports gear and anything for the kids in relation to school he was responsible for. And she's just found out that he hasn't been doing it.
Okay, well, sorry, keep going.
Yeah. And when she contacted him, he claims that he can't afford to do it. Now he agreed to do it at the mediation. He claims he can't afford to do it. He has his own business, which means it's difficult to sort of get money from him, I think.
Okay, well, that is a tricky problem, and that is something that commonly comes up. So if your granddaughter was going through family law matters, the mediation is normally a step after you've commenced proceedings in the family court. However, they may have done it before going to court. And the outcome of that would be a parenting agreement. And the parenting agreement does state who's living where, who's responsible for what sorts of decisions, etc. Now, the only way for that to be binding is for...
that's the one. It was a parent agreement in the mediation.
So the only way for that to be binding is for it to be taken to court and be given what's called consent orders, which means that they're actually an order of the court, and therefore she would be able to go to court to enforce it. If that hasn't happened and it isn't a court order, she can actually initiate court proceedings to have that parenting agreement being made as orders in the court, which would make them enforceable going forward.
But the problem, Andrew, is that she can't afford to go to court. You go to court these days, you're talking about tens of thousands of dollars, and she just doesn't have that money to challenge him that way.
Okay, I'm not sure it's necessarily tens of thousands depending on where she goes and depending on whether he's prepared to consent. But legally, if you wanted to enforce the agreement, the only real way to enforce the agreement is if it was either done through a binding financial agreement, which is unlikely for children, or through consent orders through the court. She may also be able to go through child support, because often these types of agreements they mutually agree that they're not going to go to the child support agency. However, that isn't something you can actually contract out of in Australia. If either parent feels that they need child support, they can contact the child support agency and request help that way as well.
Do you have their telephone number or contact details?
If you ring into the station after the show, I will make it available.
Oh, okay, that'll be great. That's good news. Just that she's becoming frantic. The school's asking for the school fees, etc., and she's suddenly woken up that he hasn't been doing his part of the agreement.
Well, that's very unfortunate. I would definitely. The schools are used to dealing with these sorts of problems. I would let them know what's going on sooner rather than later, so there's no enrolment issues.
Yes.
And Thomas, if you just give a call back after the show, leave your name and number, and Andrew will get you the information you require.
That's terrific. I'd appreciate that. Thank you, gentlemen. Good morning.
Good on you, Thomas. Thank you. Well, if you've got a question just like Thomas has on anything legally natured, we'd love to hear from you. 0755 208888. 15 minutes left in the show. Now, Andrew, did we adequately cover off jerry cans?
The only thing that we didn't cover is how much petrol can you actually transport in your vehicle. So there are different rules for whether it's unleaded or diesel and what sort of a car you have. So if you have a ute, it's open air and there's different rules. You can carry a bit more petrol, and that's the recommended way to go. You can carry up to 250 litres in those compliant jerry cans. If you're travelling in the car, 10 litres is the recommended limit for what you actually carry with petrol in your car. And diesel and unleaded is something I didn't know. You see the four-wheel drives with the jerry can on the back?
Yes, you
do. That's
do.
Perfectly acceptable for diesel, but unleaded isn't allowed to be somewhere where it could be affected in an accident. So
crushed.
Watch what you're putting in the jerry can on the back of the four-wheel drive.
Great advice, because people do just see the jerry can on the back and the assumption is, I can put anything I like in there. All right, moving on to defamation. Now, we did start this last week.
I'll just recap, Colin, if you like, for what defamation is, in case you weren't listening last week. But there's three major ingredients in Queensland for defamation. The first one is there has to be a statement or a publication that damages someone's reputation in the eyes of reasonable people. The second statement is that it actually identifies a particular person or business. And the third one is that it's published to at least one person. Someone actually has to have read it or heard it. That's it. It doesn't have to be in a newspaper, an email to a colleague, a Facebook post, a Google review. All of these could qualify.
Perfect.
And since 2021, there's one other thing. You must have suffered what's called serious harm. So minor disputes won't be entertained. However, serious harm has been found in cases around emails, Facebook groups, and online reviews. So serious doesn't mean that it has to be on the front page of the Courier Mail. Okay. The main defences? The biggest one is truth. So if you can prove that the statement is substantially true, then it's not defamation. Similarly, if it's an honest opinion, it's a clear expression of your opinion, not fact, based on the proper material. And the final one is something called qualified privilege, where you might have heard people standing up in Parliament and saying nasty things about people. Well, they have parliamentary privilege and they can get away with it, but mere mortals like us can't.
And that's probably a good takeaway, because we do see it on the television quite often by our politicians. They can get away with it, and it doesn't mean that we can.
Yes, that's correct. But even then, they've got limits on when they can do it and where they can do it. And Pauline Hanson was recently sued over comments she made because she didn't do them in the appropriate way in the appropriate forum.
All right, this is a Talkback program. We'd love to hear from you. Your questions run the show, and if you could see your way to a question, 0755 20 8888. 15 minutes left in the show. We'd love to hear from you. All right, truth. Let's start with that. The justification defence. Give me a case where it actually worked and the defendant walked away.
Okay, Colin. Well, I think telling stories and relating these to things in the media help people understand what's going on. So one of the biggest things was the Bruce Lehrmann case in recent times. It went for many, many months and cost millions of dollars in litigation. But essentially what it was about was that a former Liberal staffer sued Network 10 and Lisa Wilkinson over an episode of The Project where the lady that he allegedly raped described it as happening. He wasn't named in the broadcast, but he claimed he was identifiable and his reputation was damaged. So you can see those elements that we had before. There was a statement about the person. It damaged his reputation, serious harm. So he could justify those bits. The question, though, was that defence of truth. And after interviewing countless people over countless months, Justice Lee found in favour of Network 10. He found that Lehrmann had raped Brittany Higgins beyond reasonable doubt, and while it wasn't to a criminal standard, because he hadn't actually been found guilty in the criminal trial, in the defamation trial it's the civil standard, which is called the balance of probabilities, which means is it more likely or not that something happened. So after going through all of that, he said it was more likely than not that the rape happened, and therefore the allegations around the sexual assault were true, and Channel 10 was not found liable.
Okay. Well, I've got a couple of questions about that, but we've also got a phone call, so we might dive onto that. If you've got a question from Andrew Bell from Bell and Senior Lawyers, you can give us a call right now, 0755 20 8888. Very good morning to Anthony. Anthony, ask your question of Andrew.
Oh, good morning, Andrew. How do you do?
Great, thanks, Anthony. How are you going?
Good, mate. Good. Look, I was just calling in relation to the commodity issues we've got at the moment in relation to oil and gas, and just sort of letting your viewers know the aptitude of Australia and the ability we've got very quickly to turn a key if we were to develop in the time frames we could do this in to ensure we've got our own supply and not be dependent on third parties and in fact other countries. And I guess the question that if any parliamentary people are listening, that it should be the foremost of our agenda. I was the head of a global commodities company. So, I took a lot of personally took a lot of mines into production and sold it and exported for a couple of decades. That was my previous role. And, you know, I've been part of companies that we've actually raised capital to get mines into production. So I'm not talking about hearsay. I'm talking about, these are real, you know, Adelaide is one classic example where we have a huge infrastructure below the ground, which is ours, you know, and we're not paying royalties from it. And the very simple and direct solution right now is to get this into production.
Anthony, this is a legal program for legal questions. You might want to give us a call back when we have the pollies on.
So to bring that to a point, why are we not, that's a new, we call that a new mine. Why are we not in terms of legal and taking this to, you know, whether or not we have to take this to a high court or we have to take, you know, there's no royalties currently, you know.
So I think, Anthony, the problem that we're having, if we're talking about this from a legal perspective, would be standing. So forcing a parliament to do something or not do something is the realm of the High Court, and you'd actually have to have standing to actually introduce something. Unlike Switzerland, where you can have a citizen-led referendum to force political change, unfortunately, you're going to have to lobby the politicians to make this one happen.
Thank you, Anthony, for your question. And if you'd like to ask a question, and a legal question, we'd love to hear from you. 0755 208888. All right, going back to that example, the court making the finding when there was never a criminal conviction. That's an interesting point. It's a civil definition against a criminal definition. Is that right?
That's right. So criminal, the standard for the listeners, because we don't often cover this, is something that's beyond reasonable doubt. It means there's no other plausible explanation for how something happened. So the burden's on the prosecutor to get up with enough evidence to say, well, this is the only reasonable explanation about what happened. Sure. In civil, whether it's suing for a debt or defamation or other things, it's more, is it just above 51%? O.J. Simpson trial, for example, famously, he wasn't convicted of the murder of his wife, but he was later fined in the civil jurisdiction significant amounts of money for causing her death. The Ben Robert Smith defamation case, where it was alleged that he committed war crimes by Channel 9, again, a very long, very prominent thing. And again, it was found more likely than not that he did the things that he was accused of, and Channel 9 wasn't found liable in defamation. So in this area of the law, is it more likely than not that this is true?
Okay, well, that's a very interesting definition. All right, going back to the truth, when it failed, and when has the truth defence been tried and failed?
Okay, so if we go back to Geoffrey Rush, you might remember him being in court a few years ago. Famous actor, Captain Barbossa, yes, in Pirates of the Caribbean. The Daily Telegraph published a series of stories that suggested that he behaved inappropriately towards a female cast member in a play that they were doing. And this was run, and he sued them. Again, significant harm. He said that the Hollywood studios weren't hiring him anymore because of this, and it significantly harmed his reputation. The newspaper put up that they were justified, that the stories were true, and therefore that they were fully entitled to publish them. But after, again, a lengthy trial, the federal court rejected it entirely. They found that the main witness lacked credibility, there was no corroboration with the story, and that they couldn't prove even to that 51% that what was alleged happened. So he successfully sued for something like $2.8 million. $2.9 million was awarded to him for the damage to his reputation, and hopefully for him that he cleared it. So yes, you have to be really careful if you're going to state the truth, that you have some evidence that you'd actually be able to put up. And again, even if this is Facebook posts, if it has the potential to seriously harm a person's reputation, you've got to be careful of what you say.
This is a Talkback program. We'd love to hear from you on any legal related topic. 0755 208888 is the number to call. And you've got 5 minutes left in the program, so don't leave it too much longer. All right. Now
I have some social media stories as well that I could talk about, because I think that's where a lot of people are alleging that they've been defamed. A lot of people come and see me around these things, and the reason why is because it's not just the newspapers anymore, which used to be the main domain of defamation. It's easy to create a publication, and the problem with social media is you can capture a screenshot and it lasts. So there was a Queensland case just 2 years ago where someone had a Facebook group about beach crime alerts, and on that particular location, someone posted that their ex-neighbours were paedophiles. The post was only up for 90 minutes, but it clearly identified who they were. It clearly alleged a whole lot of very nasty allegations. It was proven that it was read. The court found that the couple was so severely impacted that they abandoned their plans to foster a child, and they had to move. And they found that the publication was entirely improper, unjustifiable, and couldn't find any bearing in the truth. They found that the person who posted it knew that the allegations were false, and they were ordered to pay significant amounts of damages.
Wow.
So
that's very interesting indeed. So up for 90 minutes, realised that, oh dear, we're in trouble here, pulled it down, but people had viewed it.
That's correct. And what's even more scary is in Queensland, there's other cases that have found that if you're the administrator of a Facebook group, you can be found liable for what's posted on that group by the members, even if you weren't necessarily aware of it. So the administrators of the group could also have been found liable.
All right, so that's their caution. All right, 0755208888 is the number if you would like to pose a question to Andrew Bell from Bell and Senior Lawyers this morning. 4 minutes left in the program. You do need to call pretty much right now. So defamation is a great little topic. I find it very interesting for the fact that, we work in the radio industry. We spend a lot of time educating our announcers about what's right and what's wrong, but it can be just as simple as someone saying that you're a terrible announcer and people taking affront to that and then putting it in a public forum. Is that fair?
It's sort of fair. So we covered truth before, but opinion is another area where you're allowed to state things as your opinion.
Sure.
But you've got to be very clear about what is your opinion and versus what is fact. So there's a famous case, a Media Watch, if you watch it on the ABC, where they called out what they considered sloppy journalism by a journalist, and she sued for defamation. But they went through the article, and the article had gone through, here's all the things that this person posted, here's the order, all of those quotes were true, they were from what the other person said, and then it was clear that their opinion later was based upon those facts. So if you can say that it was your opinion and you can understand that it was clearly opinion and not a fact,
yes,
then you can get away with it. But this is very subtle, Colin, and I think you've got to be very careful before posting things that could harm people's reputation. Just saying, oh, well, this is my opinion. It can't be confused with fact for you to be able to do it.
Yeah, it can't be a complete fabrication or dreamscape. All right, last chance, 0755208888 is the number to ask your question of Andrew Bell this morning from Bell and Senior Lawyers, and it's a great little topic. Now, just in summary, Andrew, we've only got a couple of minutes left in the program for defamation, summarising what we've discussed with regard to that, and then we'll come back and talk about potentially what we're going to talk about next week.
Okay, well, I think in summary you can be held liable for the things that you say and that you write. If you're going to say something that's going to harm someone's reputation, you need to either make sure that you have the basis that you could prove that it's truthful, or it's very clearly stated that this is your opinion and not a fact. And if you do those two things, you should be able to get away. And similarly, if someone has done that to you and they haven't gone through those steps, if it's clear fabrication, if it's clearly caused you serious harm, then there are things that you can do in the law to try and rectify that.
Perfect. All right. Next week, I've got a topic on the agenda, and that is QCAT. Are you happy to tackle that one?
Absolutely. So QCAT, Queensland Civil and Administrative Tribunal, It's the DIY court of Queensland.
The do-it-yourself. Well, that's going to be quite exciting. I'm sure there's limits, but we'll leave that to next week's discussion. Great information, Andrew, and we'd love to hear from you. So every Tuesday morning at 9 o'clock, if you've got a legal question, even if you just want to ask whether you've got a case or about what it is that's concerning or worrying you, you can give us a call on 0755 208888. Andrew, thanks again. And that was Andrew Bell from Bell and Senior Lawyers.
Thank you, Colin. I'll see you next week talking about QCAT.
Wills, probate, powers of attorney or property matters. Legal issues don't need to feel overwhelming. Call our trusted sponsors, Bell and Senior Lawyers. They explain everything in plain English and guide you through every step of the way. For caring, experienced advice, phone 07 55 32 3133 or head to bellsenior.com.au today. Bell and Senior Lawyers, making legal matters simple. You've been listening to Legal Matters, proudly brought to you by our trusted sponsor, Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. A copy of this and past programs and all relevant resources will be available for you to replay or download on bellsenior.com.au and 4crb.com.